When we die, we leave behind a collection of things we own, these being any money, property, and possessions such as valuable jewelry, our pets, children, and sometimes artwork, among many other things. These are assets, they hold value. Where liabilities are a person's financial debts or obligations, which are settled over time through the transfer of economic benefits, including money, goods, or services. So, what happens to all these assets and liabilities when we die? Well, you would have heard of a will. A will is a document made by an individual, often with legal aid, which sets out their wishes for the distribution of property upon death. In legal terms, this property is called an estate, being all the assets and liabilities of a person. Making a will is also important as it allows the willmaker to choose an executor, which is someone who oversees the distribution of their estate. And they can also appoint a person to act as a guardian to their children once they die. So, who can make a will? A will can be made by any person over the age of 18. Someone younger than 18 cannot make a will unless they are married or obtain a court order to do so. The court also has the power to make or change someone's will. This happens when they believe a person is unable to do so and that person would have agreed to the changes necessary. For example, a doctor can make a statement, like an oath, that the willmaker had the mental capacity to make a will. However, due to physical circumstances, they were unable to do so. This being done, a will can be made, changed, or signed for the approving patient through the court. Finally, the willmaker must possess testamentary capacity. This is like proving their mental capacity to understand the effect of what they are signing off on. To possess it, they must understand what the will is, B, the amount and type of property they have, and C, their moral obligation to provide for certain persons, such as their family and their domestic partner. When a will is constructed, there are certain requirements necessary to deem it valid. The first requirement is that the will must be written. This can be any visible form of writing. However, it cannot be videoed or recorded, as this is a perishable format and can easily be edited. The will must also be witnessed. Two witnesses must be present when the willmaker signs the will and sign it after. However, these witnesses don't actually have to know they're signing a will. They merely need to acknowledge the circumstances under which the will was signed and that the will maker signed it. The third requirement is that the will must be signed and dated. It's a requirement that all signatures on a will are signed with the same pen. So, a person can include any legal instruction into a will. They can even attach conditions to the will, controlling when and how the beneficiaries should receive the benefits. A beneficiary is a person who receives benefits under the will, such as money, property, or possessions of the deceased. However, the conditions attached to the will must align with public policy. They cannot, for instance, restrict a person doing something lawful. However, without threatening, they can offer advice through the will. As part of the will, an executor is appointed. This is a person who follows instructions regarding property within the will. They make funeral arrangements, pay debts, and arrange the distribution of assets to the named beneficiaries. Usually, the executor is someone the willmaker trusts and who is capable of managing their property. So just as there is a process of constructing a will, there's a process after the willmaker dies. This begins with finding the last will. To ensure that a will is the last one of a deceased person, 3 steps must be taken. Firstly, an advertisement is made in the local newspaper, stating that an application for a grant of probate will be made. This allows anybody holding or knowing of a later will of the deceased to come forward, keeping in mind that it is against the law to conceal a will or an addition to a will. The second step is that inquiries are made at the bank and the willmaker's solicitor's office to see if a will is being held there. And finally, the willmaker's private papers are searched to see if a later will can be found. After the last will is found, the executor of a will applies for a grant of probate. Probate, coming from the Latin word to prove, is the process in which the executor shows that a will is the last of the deceased and that they are the person named on it. Before giving a grant of probate, a register must be satisfied that reasonable action has been made to locate the last will. This being taking the 3 steps stated previously. However, a grant of probate is not always necessary. It's only required for large estates, or if someone's going to sell or rent real estate which is inherited through the will. A grant of probate authorizes the executor to deal with the assets owned by the deceased. After the grant of probate is given, the executor takes steps to arrange the disposal of the body, pay for funeral expenses, pay debts, and then locate assets and deal with them as required in the will. Well, this process of making a will, and then the process of inheritance, seems relatively straightforward. There are complications and issues which often arise within the process. One main issue is when someone either doesn't make a will, makes an invalid will, or only gives instructions to distribute part of their estate. When this happens, it is said that the person dies intestate. However, if a will is declared invalid because it was not properly executed, a court has the power to still declare the will valid if they think that the document was intended to be the person's will. When someone dies intestate, their assets are distributed accordingly to the Administration and Probate Act, made in 1958, Victoria. If no will is found when a person dies, just like when applying for a grant of probate, there are steps that must be taken to ensure no will exists. Advertisements are made to check that no will exists, and the bank, legal parties, and families consulted to check if a will is being held. Private papers of the deceased are also checked. And when a will can't be found, a letter of administration is granted. This gives the authority of the state to administer the estate. The administrator acts like the executor. They pay debts and distribute the estate. However, as no will has been written, they distribute accordingly to law. This is a major issue when it comes to not making a will, as the statutory order in which an interstate's estate is distributed is fixed and no special account can be made for the deceased's wishes. The order of the division of property when a person dies intestate is according to an order of relations. This is like an order of next of kin. This order is generally the partner of the deceased, the children, the parents, then the siblings, and if after this there are no next of kin, the property goes to the Crown, the state. So for example, Sally dies, leaving behind no partner, but children, including one child who dies before her. In this case, each living child is entitled to one equal share, while the deceased child's share goes to the next of kin of that deceased child. Another issue that may come with writing a will is the fact that the will may need changing after an initial will has been made. If someone wants to make minor changes or an addition, they add what's called a codicil. This is an amendment to a person's will and is signed, dated, and witnessed just like a normal will. If the changes to a will are major, the will is revoked. A will is also revoked when a new will is made, if a will is destroyed, or when the will maker marries or remarries. When it comes to divorce, it invalidates any gift left to ex-spouse and the appointment of them as the executor. Generally, after divorce, the partners should make a new will. So, as with any legal action, there are disputes, and often the aim of certain laws need to be interpreted so that everyone's interests are protected. To avoid disputes, the court will interpret the wishes of the will maker, this being the meaning of their words in the will and the legislation that sets down guidelines for providing for immediate family. When disputes do occur, people can seek the help of methods such as mediation and community legal services, and in some cases, the Supreme Court. People may also use these methods to contest a will. Any person for whom the will maker had a moral obligation to make a provision can claim to contest a will. They contest a will if they believe the estate is unfair or if they believe that the will is invalid. The will could be invalid for many reasons, such as it being tampered with, or that the will maker was incapable of making that will. The legal system aims to protect the individual rights of a person. So when someone contests a will or have disputes about a will, the court must decide the intentions of the will maker in order to resolve those disputes. This can obviously be challenging as the will maker is deceased. However, laws included in the 1997 Wills Act aim to be inclusive of modern language used in wills. This is evidence that the legal system is able to adapt to the changes in society in relation to making and changing wills. So, in summary, someone over the age of 18 who possesses testamentary capacity is able to make a will. In their will, they appoint someone they trust as an executor to be in charge of the distribution of their estate. Once the will maker dies, the executor ensures that the last will of the will maker has been found and then applies for a grant of probate. When this has been awarded, the executor may distribute the assets and liabilities. However, this process is not always as simple as disputes happen and people can contest a will. The courts use their power to protect the wishes of the will maker and the rights of the people that it affects. I really hope this explanation has helped you gain a deeper understanding of wills and inheritance and the way that they affect everyday people. Thank you.